Well, thank you all for coming this evening. My presentation is the legal aspects of collaborative transitions. And I call it collaborative transitions instead of collaborative divorce because not only does this material in collaborative law apply to married people, but people that have domestic partnerships and are otherwise not married. Since I'm an attorney, I got to do a disclaimer, okay? This material is a brief presentation on collaborative law. It is not designed to give individual advice on individual legal situations to anyone. We suggest that if you do have specific questions, that you contact a qualified and competent, collaboratively trained attorney to get more information. So, with that out of the way, what is collaborative law? Well, collaborative law focuses on introspection rather than reaction. It's future-oriented. It lessens collateral damage to children, and it increases the possibility of effective co-parenting. I find that the best way to explain collaborative law is to compare it with other types of relationship transitions. And the first one that most people think of is a standard traditional divorce. And as you can see, I have up on the screen what the legislature thinks is a standard traditional divorce. I don't know how many people in the audience think that they have a relationship like that, but I certainly never have. But that's the premise that the legislature starts with. And the legal system is driven by statutes. And statutes are created by the legislature, and legislatures make assumptions that are driven by political considerations, and they're designed for social control through a legal system. Statutes are a framework that are set for judges to follow, and the judicial system is a very dull instrument when it comes to assessing and enforcing individual needs, wants, desires, interests, and values. Logically speaking, valid conclusions, resolutions, and positive change cannot be based on faulty premises. One of the premises that is something to consider is, if you take a look at the standard traditional divorce, it starts with what the concept of a relationship is. The legislature thinks that a relationship is a marriage between a man and a woman. And as we all know, not all relationships are based on that, and not all people are married that have committed relationships. So we go from there, from that premise, within the litigation or the courtroom legalistic concept of what a divorce is or relationship transition. And you can see that anybody that's married, validly married, can go ahead and get unmarried based on these grounds. But it's kind of a very limited club. And it's based on incompatibility, cruel and inhuman treatment, adultery, and abandonment. Many of these concepts are outmoded, and they set people up for polarized thinking. We have lots of myths that the statutes are based on. And I like Atticus Finch here in To Kill a Mockingbird. We all have myths that we grow up with. But some of the myths that we see are perpetuated on TV and otherwise. You know, it's like people just go into a courtroom. Lawyers go into a courtroom, and that's where justice happens. Well, I'm here to tell you that not always does justice happen in a courtroom. Another myth is that you'll get somebody like Atticus Finch, who is a legal gladiator, and because he's so good, and because your case is so strong, you will win. The good side always wins in court, and the bad side always loses and are taught a lesson by the judge. Well, that's the myth. The reality is that you get a nameless stranger that you don't meet until you get into court. And he or she is dressed in a black robe, and they make decisions about your entire life and how you're going to live it afterwards that are based on maybe some other faulty premises besides the statute. Timing is dictated by a court docket. Decisions are made by a judge with limited information in a very short time frame. It may seem like it takes forever to get into court, okay, but you don't spend much time there. Well, that's typical. Negotiations and settlement are based on a legal positional information obtained through a process called formal discovery. We don't have enough time to go into what discovery is, but let it suffice to say that it is a very arcane, Byzantine, time-consuming, and expensive way of getting information that's needed to solve disputes and resolve relationship matters, and you get to transition. Expert witnesses are also used in court, and they're hired guns, just like the lawyers are. They only see one side of the case. And the attorneys are positioned against each other, and the people are positioned against each other to get the message across, and that's their message and their side, and then the judge decides. So what's the reality? Well, the reality of divorce is that it inflames people and it destroys families. The reality of traditional divorce is it forces people to make decisions with lifelong consequences when they are least able to make them due to diminished capacity. For many people, the statistics say, it takes 18 months to 4 years following a separation to fully recover. There are good things. There are pros and cons as far as various transitional models. The standard adversarial litigation, there's good things to say about that. There's good things to say about mediation. And there's good things to say about collaborative law. Let's start here with the default position, the adversarial litigation approach. The positives are it supports anger without violence, which is really a great thing about litigation. It equalizes power differentials. If there's serious domestic violence, alcohol or drug abuse or psychiatric disorders or dishonesty or a lack of good faith that prevents people from being honest at the table and really coming to the table in the spirit of resolving and getting to constructive change. Litigation is one alternative. Another thing that is either a pro or con, depending on your point of view, is litigation allows people to avoid personal responsibility. Of course, the negatives we've already alluded to. It's an obscure process, it's fragmented, it takes away people's individual control. More importantly, the negatives of litigation is it can destroy interpersonal and children's emotional tranquility and peace. And it ensures ongoing conflict. Finally, litigation has financial attrition. As far as another alternative, there's mediation. Mediation's great, and it's oftentimes done throughout an adversarial litigation. Sometimes judges will say, you gotta see a mediator. Well, mediation's great, and we have somebody that'll talk about mediation later on in this presentation this evening. But what's an improvement over mediation is collaborative law, because you have a series of professionals besides the mediator that can assist people get to the root of and focus of what their values and interests are, and to come up with a lasting peace. So why collaborative law? Here's the War of the Roses. Anybody see the War of Roses? You seen the War of the Roses? Well, some people think that that's the typical situation. Well, I've seen a lot worse personally in divorces. People can lose all self-control. I've seen better. But I'll say one thing that I do know, and that is the art of war is not the best way to create peace. As much as 95% or more of the fees that you pay your traditional divorce lawyer may be devoted to preparing for an event that actually happens less than 5% of the time. That's a trial. With collaborative law, 100% of the work is devoted to an event that happens 95% of the time, and that's a settlement. Did you know that 25% of youths from divorced families have serious emotional or psychological problems? That's compared to 10% from intact families. Well, one of the reasons for that is because they're witnessing their parents model controversial behavior and arguing all the time. Collaborative law, on the other hand, is an opportunity for parents to show that yes, if there's a conflict, it can be successfully and constructively resolved. So how does collaborative law work?